My name is Theda Whitfield. I am 70 years old and I live in Henderson, Nevada. 3 weeks ago, I stood beside my husband's open coffin while my 3 children huddled in the vestibule and whispered about splitting the assets. They glanced at me once, then looked away, as if I were furniture. I said nothing. Not because I was weak, because I was counting. 4 days later, my phone rang. Unknown number. A man's voice said, "Mrs. Whitfield, your husband hired me 11 months ago. He told me to call you today. Come now, tell no one." I grabbed my keys and drove straight to Reno. What happened in that attorney's office changed everything, and none of my children saw it coming. Welcome back to Alpha Mom Stories. This is where real families face real choices and real consequences. If you have ever been underestimated by people who should know better, drop a comment, hit subscribe, and let's begin. Henderson sits in the desert southeast of Las Vegas, where the subdivisions thin out and the air smells like warm concrete and sage. Harold and I bought our house there in 1985 for $72,000. 3 bedrooms, a 2-car garage, and a backyard that faced the McCullough Range. That house is worth $620,000 now, but we never thought of it in dollars. We thought of it in years, 41 of them. Harold was a mining engineer, gold mines mostly. He spent his career underground in the Carlin Trend region, Elko Winnemucca Battle Mountain, measuring ore grades and planning blast sequences. 40 years of 12-hour shifts, 4-day hitches, and gravel roads. He retired in 2019 at 65. On his desk, next to a stack of geological survey maps, sat a brass field compass he carried every working day of his career. Scratched case, cracked glass. The needle still settled true. He never replaced it. He said it had earned its scars. I retired the year after Harold in 2020. I spent 30 years as an Elder Protective Services investigator for the Nevada Aging and Disability Services Division. My job was simple to describe and brutal to do. I investigated cases of senior citizens being financially exploited by their own families. I interviewed victims, traced missing funds, documented fraud, and testified in court. In 30 years, I handled 847 cases. Harold used to say our jobs had something in common. He measured rock. I measured people, and both of us knew when something was hollow. We married in 1978, 48 years. We raised 3 children in that Henderson house, and we built everything together. Nevada is a community property state. Everything earned during the marriage belongs to both spouses equally. Harold never forgot that. Our children did. In March 2025, Harold was diagnosed with pancreatic cancer, stage 3. The oncologist at Sunrise Hospital gave us the numbers: median survival 14 months with treatment. Harold nodded once, the way he acknowledged blast reports underground. Then he asked when he could start chemotherapy. I became his full-time caregiver. I drove him to appointments, managed his medications, tracked his weight, and charted his pain on a yellow legal pad I kept by the bed. I had spent my career documenting other people's crises. Now I was documenting my own. The children came to visit within the first week, each of them, separately. And each of them said something that made me pay attention. Constance, our eldest, arrived first. She hugged Harold, sat at the kitchen table, and said, "Have you reviewed the trust documents recently? I should probably take a look since I'm the successor trustee." Lloyd, our middle child, called that evening. His first question after the diagnosis: "What about the cabin? Is the cabin in the trust?" Edgar, the youngest, came by on Saturday with a leather portfolio. "I can update the estate plan for you, Dad, pro bono. Family shouldn't pay for family." Not one of them asked about treatment options first. Not one asked about pain management or dietary needs, or whether Harold could still take the stairs. The diagnosis was 4 days old, and my children were already running numbers. I noticed. 30 years of my career trained me to watch for exactly 3 things: who asks about the money first, who offers to help with the paperwork, and who never mentions the patient. Harold saw my face that night. He took my hand. "Let them talk, Theda. I know what I'm doing." I didn't know what he meant, but I trusted him. Constance was 46, our firstborn. She married Douglas Bradshaw in 2002, a man who had charm and credit in roughly equal amounts. Douglas built a chain of 3-car dealerships in Henderson, Chevrolet, Hyundai, and a used lot on Boulder Highway. For 15 years, the Bradshaws lived well. Country club membership, a house in Anthem with a pool and a view. Constance hosted charity luncheons and served on the PTA board. In 2024, all 3 dealerships closed within 8 months. Bad inventory bets lease obligations he couldn't renegotiate, and a market that shifted to online sales faster than Douglas could pivot. The personal debt totaled $380,000. Douglas took a sales job at a competing dealer. Constance stopped hosting luncheons. I knew about the financial trouble because Harold told me, but Constance never said a word to us. She kept the Anthem house. She kept the country club dues. She kept appearances. The thing about Constance, she always believed she deserved to lead the family. Firstborn logic. When Harold and I created our revocable living trust in 2004, Constance lobbied to be named successor trustee. We agreed. She was the oldest. It seemed natural. After Douglas's dealerships collapsed, something shifted. Constance drove to our house one Sunday afternoon. She sat in the driveway for 40 minutes. I watched her from the kitchen window. She never came inside. She drove home. 2 weeks later, she called the brokerage that held our trust investments and requested copies of the quarterly statements. She told them it was for trust administration purposes. She had the authority. She was the successor trustee. In my career, I watched this pattern hundreds of times. The exploiter always starts with the documents. They need the numbers before they make their move. Lloyd was 43, our middle child. He went into real estate development after college, not the careful, measured kind. Harold practiced, but the leveraged kind. Big plans, borrowed money, quick timelines. His current project was a 36-unit townhome development in North Las Vegas. It was $1.1 million over budget. The construction lender had sent 2 default notices. Lloyd needed $800,000 to finish the project, or he would lose everything, including the personal guarantee he'd signed with his own name. Lloyd's wife, Ruth, grew up in Pahrump. If you know Nevada, you know Pahrump. Small town, desert floor. Her family lived in a single-wide trailer off Highway 160. Ruth married Lloyd, believing she would never be poor again. When the project started failing, Ruth's survival instincts ignited. It was Ruth who found the bank statement. She was in our kitchen during a Sunday visit while I was in the backyard with Harold. She opened the drawer by the phone, the one where I kept envelopes and stamps, and found a quarterly statement from our investment account. $1,400,000 in managed funds. Ruth photographed it with her phone. That night, she told Lloyd, "Your parents are sitting on $1.4 million and you're about to lose everything." After that, Lloyd started visiting Harold at chemotherapy appointments, alone, without me. He called it father-son time, but Harold told me what they talked about, the cabin. We owned a small cabin in Incline Village on the north shore of Lake Tahoe. We bought it in 1998 for $215,000. It was worth $980,000 now. Lloyd kept bringing it up during chemo. "Nobody uses it 9 months a year, Dad. It's just sitting there." Harold told me he handled it. I believed him. Edgar was 39, the youngest. He had a law degree from UNLV Boyd School of Law, trusts and estates solo practitioner. He opened his own firm in 2016 with 2 modest clients and a lease on a small office near the courthouse. For a few years, it worked. Then it stopped working. By early 2025, Edgar had lost 2 major clients. One died. The other moved to Arizona. He was 3 months behind on office rent and had started taking court-appointed guardian cases just to keep the lights on. His law degree was supposed to be the family's crowning achievement. Now it was a title on a door nobody knocked on. Edgar looked at our parents' estate, the way an engineer looks at a bridge structurally. He saw $4.2 million in total assets that under the current trust would go to me for my lifetime, with the children receiving only remainder interests after I passed. Edgar considered this arrangement inefficient. He said that word at Thanksgiving 2024. Inefficient, as if my continued existence were a budget line item. He started visiting Harold at the hospital. He always brought a leather portfolio. Just updating your beneficiary designations, Dad. Standard stuff. Harold signed a few things. Harold told me later he was too tired to read every page. One Tuesday evening, I came home from the pharmacy and found Edgar in Harold's study going through the filing cabinet. He straightened up when he saw me. I was looking for the original trust document, for reference. I've interviewed hundreds of people who said I was just looking. In 30 years, not one of them was just looking. What I didn't know then was that Edgar had already drafted something far worse than an update. Harold's condition worsened through the summer and fall of 2025. By August, he was on outpatient hospice. He could still walk, still talk, still drive, short distances. But the chemotherapy had hollowed him out. He weighed 142 pounds. His hands shook when he held his coffee cup. The children accelerated. Constance, using her access as successor trustee, redirected a $12,000 quarterly dividend payment from our trust investment account to her personal Chase checking account. She coded it trustee distribution, discretionary. The trust instrument contained no provision authorizing discretionary distributions to the successor trustee. I did not know about this transfer at the time. Lloyd brought Harold a quitclaim deed for the Incline Village cabin during a July chemotherapy appointment. Harold was sitting in the infusion chair, an IV in his left arm, when Lloyd slid the paper across the tray table. Harold signed it. He told me that evening, "I signed something today I shouldn't have, but I'm going to fix it. Trust me, Theda." Between August and October 2025, Harold drove to Reno 3 times, 6 hours each way from Henderson. He told me he was visiting old mining friends. He came home smelling like desert sage and road dust, his brass compass on the passenger seat, where he always kept it when he drove north. "A compass doesn't argue," he once told me. "It just points where it needs to go." In Reno, Harold was meeting Calvin Shea, his college roommate from the University of Nevada class of 1976. Calvin had become an estate planning attorney. Harold hired him independently. None of us knew Calvin existed. Together, they executed 3 documents. I would learn what they were 4 days after the funeral. On October 8, 2025, Harold gave Calvin Shea a sealed brown accordion file folder with a rubber band, his handwriting on the front for Theda. He told Calvin, 4 days after my funeral, call her, not before. Harold's final months were the quietest of our marriage. He sat in his study with the compass on his desk, watching the desert light move across the floor. I brought him meals. We talked about small things. The quail in the yard, the neighbor's new fence, whether the Meyer lemon tree would fruit again. He did not talk about the children. He did not talk about the trust. On July 15, 2026, a Wednesday, Harold died at home. I was holding his hand. The hospice nurse checked for a pulse, looked at me, and nodded once. I sat with him for 11 minutes before I called anyone. The children arrived within the hour, together without being summoned, as if they had been waiting. Constance took charge of the funeral arrangements immediately. She chose the casket, $8,400 mahogany with brass hardware. Dad deserves the best. Lloyd booked the chapel at Palm Mortuary. Edgar wrote the obituary. He listed each child by name with professional titles. He described me as his wife. Nobody asked me what Harold would have wanted. Nobody asked what songs he liked, what scripture mattered to him, what suit he preferred. They planned his funeral like a board meeting I was not invited to attend. That evening, I stood in the hallway outside Harold's study and heard Constance on the phone with Edgar. Her voice was low, certain, dismissive. She's still breathing, but she's already done. I memorized the phrase. Date July 15th. Time 9:47 p.m. Speaker Constance. Exact words recorded. In my line of work, we called that a declaration against interest, a statement so cruel that no reasonable person would make it unless they meant every syllable. The funeral was Saturday, July 18th, Palm Mortuary, Henderson. A chapel with cream-colored walls and recessed lighting, and the faint hum of an air conditioner working against the July heat. Harold lay in the mahogany casket in his navy suit, the one he wore to our 50th anniversary dinner that never happened because cancer doesn't wait for milestones. I placed his brass compass in his jacket pocket before the viewing. I planned to take it back before they closed the lid. 94 people signed the guest book. Mining colleagues from Elko and Winnemucca, neighbors from our street, members of our church. Harold's former crew foreman drove 7 hours from Battle Mountain. He shook my hand and said 3 words. He was solid. That was enough. Through the glass partition, I watched my 3 children in the vestibule. Constance stood with her arms crossed. Lloyd had his phone out, tilting the screen toward Edgar, showing something. Photos of the cabin, I learned later. They were not crying. They were pointing, gesturing, dividing. Edgar said something I could not hear. All 3 of them glanced at me. Then they looked away and continued. 94 people came to honor my husband. 3 of them came to divide him. Before they closed the casket, I reached into Harold's jacket pocket and took back the compass. The brass was warm from the chapel lights. I held it in my left hand through the rest of the service, through the prayers, through the drive to the cemetery, through the lowering of the casket into Nevada dirt. I did not cry at the funeral. The grief was there, heavy and permanent. But I was watching. After the reception, the children descended on the house like a survey crew, mapping a claim. They had roles. They had tools. They had purpose. Constance walked into Harold's study and opened the filing cabinet without asking. She pulled the trust folder. The green hanging file labeled Whitfield Family Trust, 2004, and began sorting pages on Harold's desk. I need to locate the original trust instrument. As successor trustee, I'm responsible for administration. Lloyd moved through the house with his phone photographing the artwork, the furniture, Harold's gun safe in the garage, the Craftsman tool collection, the shelving unit full of geological samples. He texted Ruth from the living room. I saw the screen over his shoulder. The Remington alone is probably $800. Edgar sat at the kitchen table with his laptop open and asked me to step aside so he could review documents without distraction. Ruth arrived at 4:30 with a stack of empty cardboard boxes. "Just in case we need to organize anything," she said, setting them in the hallway. I sat in the kitchen. I watched. Constance's words from 2 nights earlier returned, settling into the room like a draft under a door. She's still breathing, but she's already done. She was operating on that belief. They all were. I was present in the house, but absent from their plans. In 30 years at the division, I investigated 847 cases of elder financial exploitation. The first thing the exploiter always does secure the documents. The second thing, inventory the assets. The third thing, isolate the target from outside counsel. The fourth thing, tell themselves it is justified. 4 people, 4 roles, 1 target. I had spent my career memorizing this playbook. I just never expected to see it performed in my own kitchen. 2 days after the funeral, Monday, July 20th, the 3 children arrived at my front door at 9 in the morning. Together, on time, with a printed spreadsheet. Constance led. She sat across from me at the kitchen table, unfolded the spreadsheet, and smoothed it flat with both palms. Lloyd stood behind her. Edgar leaned against the counter with his arms folded. "Mom, we've put together a plan for the estate." The spreadsheet had columns. Asset, value, allocation, beneficiary. Henderson House, $620,000. Sell, split 3 ways. Incline Village Cabin, $980,000. Transfer to Lloyd. Dad signed the deed already. Investment portfolio, $1,400,000. Edgar manages as family fiduciary. Harold's retirement accounts, $680,000. Constance controls as successor trustee. Mineral rights mining stock, $520,000. Liquidate. Split 3 ways. Life insurance, $400,000. Split 3 ways. At the bottom of the spreadsheet in bold, Theda, assisted living facility, Summerlin. Monthly cost $4,200. Funded from investment income. I read every line. I noticed what was missing. The spreadsheet did not include the community property calculation. It did not include my spousal rights. It treated me as a dependent, not a co-owner. Edgar said it quietly, looking at the wall behind me, not at my face. She had Dad's last year's. We get the rest. Constance added, "You don't need a lawyer, Mom. We're your family." I looked at the spreadsheet for a long time. Then I folded it once, set it on the table, and said 4 words. "I'll think about it." That was all I gave them. They exchanged satisfied looks. They thought compliance had a sound, and it sounded like silence. That evening, I sat alone in Harold's study. The compass rested on the desk where it always sat, next to the geological maps and the small jar of desert stones he collected from every mine he worked. The sage-scented air drifted through the window screen. July evenings in Henderson still carry heat, but the air softens after dark. I replayed Constance's voice. She's still breathing, but she's already done. I turned the phrase over the way I used to turn evidence in my hand, examining it from every angle, looking for what it revealed about the person who said it. It revealed confidence. It revealed planning. It revealed a daughter who had already moved past grief and into acquisition. But I did not feel wounded. I felt familiar. This was the playbook. I had seen it 847 times. I made a mental list of what I had observed since Harold's diagnosis. Constance accessed investment accounts as successor trustee and requested quarterly statements. Lloyd obtained a signed quitclaim deed for the cabin during a chemotherapy appointment. Edgar was found in Harold's study going through the filing cabinet. Ruth photographed a bank statement from the kitchen drawer. I could document all 4 actions. But I could not prove intent. Not yet. And I had no idea about Harold's plan. His secret trips to Reno, the meeting with Calvin Shea, the sealed accordion folder, those were still invisible to me. I picked up the compass from the desk. The weight of it steadied my hand. Harold had said, "Trust me." So I waited. In my career, I learned that patience is not passive. It is the disciplined refusal to act before the evidence is complete. I set the compass on the kitchen counter. I made a cup of tea. I did not pack. Tuesday, July 21st, 3 days after the funeral. Edgar arrived alone at 10 in the morning. He carried a manila folder. He did not knock. He used the garage code and walked in through the laundry room the way he had done since he was 12. "Mom, I found something in Dad's files." He set the folder on the kitchen table and pulled out a 2-page document. First Amendment to the Harold and Theda Whitfield Family Trust. Dated September 2025, it named Constance Lloyd and Edgar as equal immediate beneficiaries. My interest was eliminated. "Dad signed this last fall," Edgar said. "It changes the distribution." I took the document. I read both pages slowly. I am not a lawyer, but I have read thousands of legal documents in my career. Guardianship petitions, powers of attorney, trust instruments, deed transfers, financial affidavits. I have testified about forgeries in 74 court proceedings. I turned to the signature page. I have seen Harold's signature on 10,000 documents over 48 years. Tax returns, mortgage papers, birthday cards, Christmas letters, medical consent forms. His capital H always began with a short downstroke. The cross on his T in Whitfield angled upward at roughly 15 degrees. The baseline of Harold held a perfect horizontal, the steadiness of an engineer's hand. The signature on this page was wrong. The T cross was flat. The H started too high. The baseline of Harold dipped on the second syllable. I said nothing about the forgery. I handed the document back. "Thank you, Edgar. I'll have someone review it." "There's nothing to review. It's Dad's signature." "I'll have someone review it." He left. I sat down. My hands were steady. In my career, I referred 43 suspected forgeries to the district attorney. I know what I'm looking at. Tomorrow was day 4. Wednesday, July 22nd, 9:47 in the morning. I was sitting at the kitchen table with a cup of coffee that had gone cold when my phone buzzed against the placemat. Unknown number, area code 775, Reno. Mrs. Whitfield, my name is Calvin Shea. I'm an attorney in Reno. Your husband hired me 11 months ago. He told me to call you on this exact day. My hand tightened on the phone. Calvin continued, he said to tell you, come now and tell no one. I asked one question. Why today? Because Harold said you'd need 4 days. 1 day to grieve, 1 to listen, 1 to watch, and 1 to decide. I stood up. I put on my shoes. I took my purse and my keys. Harold's compass sat on the kitchen counter where I had left it after the funeral. I picked it up and put it in my jacket pocket. I did not call my children. I did not text them. I locked the front door, backed out of the driveway, and turned north on I-15 toward US 95. Henderson to Reno is roughly 450 miles, 6 hours and 12 minutes if you stop once for gas. I stopped in Tonopah, bought a bottle of water and $37 of fuel, and kept driving. The compass sat on the passenger seat. The desert unrolled on both sides. Creosote flats, Joshua trees giving way to juniper and sagebrush as the elevation climbed. Harold drove this road 3 times in his last year. He told me he was visiting old friends. He was visiting Calvin Shea, and he was building the only thing he could still build a wall between me and what was coming. Calvin Shea's office sat on South Virginia Street in Reno. I parked at 322 stiff from 6 hours of highway. Calvin was 74, gray-haired Harold's college roommate from the University of Nevada in 1974. He led me to a conference room overlooking the Truckee River. On the table, a brown accordion file folder with a rubber band. Harold's handwriting on the front for Theda. Calvin said, Harold drove up from Henderson on October 8th of last year. He said he had to do it in person. I opened the folder. 3 items inside. The first was a trust amendment. Second Amendment to the Harold and Theda Whitfield Family Trust. Executed October 8th, 2025. Witnessed by Calvin, notarized by Diane Corbin in Washoe County. It removed Constance as successor trustee and replaced her with Silver State Trust Company. It named me sole lifetime beneficiary of all trust assets. The children would receive remainder interests only after my death. And it contained a no-contest clause under Nevada Revised Statutes, Section 163-195. Any beneficiary who contested the trust would forfeit their entire beneficial interest. The second was Harold's handwritten letter, 3 pages, his handwriting shaking by page 2. I know what they're doing, Theda. Constance has been moving money. Lloyd got me to sign a deed. I fixed it. Edgar brought me documents with my name that I never signed. And I couldn't tell you because you would have tried to give them another chance. Some people don't change. They just get better at what they are. And that compass got me through 40 years of dark tunnels. I hope it helps you through this one. The third was documentation. 4 pages. Constance 4 dividend transfers totaling $47,000. Lloyd quitclaim, deed under duress revocation recorded August 2025, Washoe County document 2025-42871, Edgar fabricated trust amendment with forged signature. Calvin said quietly, Edgar told your husband something during treatment in April. Harold wrote it down. She had Dad's last years. We get the rest. He said it to Harold's face, while Harold was in the treatment chair. I wept, first tears since the funeral, not from anger, from the weight of a man who could barely hold a pen, driving to Reno 3 times to keep his wife safe. Calvin gave me a business card, Julia Keating, estate litigation attorney. Harold wanted you to have the best. If you are thinking about your own family's trust right now, stay with me. What happened next taught me something no legal document can explain. Drop a comment if Harold's letter reached you. I sat in Calvin's conference room for another hour and read Harold's letter from the beginning 3 more times. I read it the way I used to read case files, absorbing every detail, anchoring each fact to a timeline. Harold discovered Constance's dividend redirections in June 2025 when he reviewed a quarterly statement she didn't know he'd requested directly from the brokerage. He noticed the $12,000 transfer coded as trustee distribution. He checked the trust instrument. There was no provision authorizing discretionary distributions to the successor trustee's personal account. He checked the next quarter. Another $12,000. He did not confront Constance. He documented it. He found Edgar's forged trust amendment in September 2025. Edgar left a draft on the printer at our home, our old inkjet in the hallway alcove. Harold saw it before Edgar came back to collect it. He compared the signature to his own. He knew immediately. Ruth's document photography Harold confirmed with a simple test. He placed a specific bank statement in the kitchen drawer at a precise angle, noted the position in his records, and checked after Ruth's next visit. The statement had been moved. He photographed the drawer before and after. Harold wrote in his letter, "I didn't tell you because I needed to move fast. The amendment had to be executed before I was too weak to sign my own name. Calvin witnessed it. The notary certified it. It's real, Theda. It's iron." His final line, "You spent 30 years protecting other people's parents. Let me protect you this once." Calvin explained the legal landscape. The amendment was properly executed under Nevada law. It superseded all prior versions, including Edgar's fabrication. The no contest clause under NRS 163.0195 was enforceable. Any child who contested would forfeit their remainder interest entirely. I drove home that afternoon. 6 hours. I did not turn on the radio. Harold's compass sat on the passenger seat pointing north the whole way. I got home at 11 at night. The porch light was off. Nobody had checked on me. I had been gone for a full day, 14 hours. In that time, my children had been busy. Constance had arranged for a real estate agent to walk through the Henderson house. The agent's business card sat on the kitchen counter next to a notepad with room measurements written in pencil. Estimated list price $625. Lloyd had driven to Incline Village and changed the locks on the cabin. He texted me at 2:15 that afternoon, "Just securing the property for the family mom." Edgar emailed me the forged trust amendment as a PDF attachment. Subject line, "Dad's trust amendment. Please review and acknowledge receipt." Ruth removed a cardboard box of Harold's personal files from the garage. She left a sticky note on the empty shelf. "Took for organizing, Ruth." I stood in my kitchen and looked at all of it. The business card, the text, the email notification on my phone, the empty shelf. I did not respond to any of it. The next morning, Thursday, I called Julia Keating's office and scheduled an appointment for Friday, July 24th. Then I photographed everything: the realtor's card, Lloyd's text message, Edgar's email, the sticky note, the empty shelf in the garage. I used my phone's timestamp feature, the same method I'd used for 30 years of field investigations. I made a list in my own handwriting on a yellow legal pad, not for evidence, for clarity. Constance unauthorized trustee access, dividend diversion realtor engagement without owner consent, Lloyd cabin lock change text message claiming authority, Edgar forged amendment email requesting acknowledgement, Ruth file removal. In 30 years, every investigation started the same way: a list of facts. No opinions, no emotions, no adjectives. Facts. I slept in my own bed, in my own house, in a bedroom that still smelled faintly of Harold's soap. I did not pack. Friday was 2 days away. I had an appointment with a woman who fights for a living. Julia Keating's office was on the 14th floor of a building on South 4th Street in downtown Las Vegas, 6 miles from the courthouse. Her receptionist offered me water. I declined. I was not there for hospitality. Julia was 52. Short, dark hair, no-nonsense posture, a voice that stayed level the way mine does. Trained calm. She spent 22 years in estate litigation. She had handled trustee removals, trust contests, beneficiary disputes, and fiduciary breach actions across Clark Washoe and Nye counties. I placed Harold's accordion folder on her desk and explained the situation in the order it happened. She listened without interrupting. When I finished, she opened the folder and read the trust amendment first, then the letter, then the documentation. After 17 minutes, she looked up. The amendment is ironclad. Properly executed, witnessed, notarized, and dated. It supersedes everything prior, including whatever your son fabricated. The no contest clause under NRS 163.01195 is enforceable. Any beneficiary who challenges this in court forfeits their remainder interest. Julia flagged 3 investigative priorities. First, a forensic accounting of Constance's dividend redirections. Trace every dollar, confirm no trust authorization. Second, a handwriting analysis of Edgar's forged amendment. Certified forensic document examiner, court qualified. Third, confirmation that Harold's revocation deed for the cabin was properly recorded at Washoe County. Julia's retainer was $15,000. The forensic accountant would cost $8,000. The handwriting expert, $3,500. Total initial outlay, $26,500. I had the money, community property. Harold and I had built our savings together over 48 years. I wrote Julia a check that afternoon without hesitating. In 30 years, I watched families lose everything because they would not pay for a lawyer. I was not going to make that mistake. Julia's first action, file a notice with Silver State Trust Company, accepting their appointment as successor trustee under the October 2025 amendment. Week 1, late July. Julia retained Kendall Marsh, a forensic accountant based in Las Vegas. Kendall subpoenaed the trust investment account records from the brokerage using the trust's legal authority. Silver State Trust Company, now acting as successor trustee, authorized the request. The records arrived within 6 business days. They confirmed everything Harold had documented. 4 unauthorized transfers from the Whitfield Family Trust investment account to Constance Bradshaw's personal Chase checking account. March 15, 2025, $12,000. May 1st, $12,000. July 1st, $12,000. September 15th, $11,000. Total $47,000. Each transaction coded trustee distribution, discretionary. Kendall's preliminary finding: the trust instrument contains no provision authorizing the successor trustee to make discretionary distributions to her own personal account. These transfers constitute unauthorized self-dealing. Week 2, early August. Julia retained Dr. Alan Finch, a certified forensic document examiner with 26 years of experience. She provided him with 12 known signature samples from Harold: tax returns, mortgage documents, the real trust amendment, medical consent forms, and Harold's voter registration card. She also provided Edgar's submitted First Amendment. Dr. Finch began his analysis. His report would take 10 business days. Meanwhile, my children continued their plans as if nothing had changed. Constance contacted a second real estate agent about listing the Henderson house. Lloyd hired a contractor to begin renovations at the Incline Village cabin, new kitchen countertops, and a bathroom remodel. Edgar filed a notice of trust with the Clark County recorder, using the forged amendment as the operative document. I knew about all of this because Julia was monitoring public filings and because I still received mail at my own address. I did not intervene. I did not warn them. Julia told me, "Let them move. Every step they take now is a step they'll have to explain later." Week 3, mid-August. Dr. Finch completed his analysis. His report was 9 pages single-spaced with photographic comparisons at 12 times magnification. Conclusion: the question signature on the document titled First Amendment to the Harold and Theda Whitfield Family Trust does not match the known signatures of Harold J. Whitfield. I identified 17 points of divergence in letter formation, pen pressure, and baseline alignment. The T crossbar in Whitfield lacks the consistent upward angle present in all 12 known samples. The baseline of Harold shows a characteristic dip on the second syllable not present in any genuine signature. Opinion: the question signature is a simulation, a deliberate attempt to replicate the genuine signature. It is not genuine. 17 points. That number would matter later. Kendall Marsh's final forensic accounting report arrived the same week. All 4 transfers confirmed. No trust authorization. Constance had acted beyond the scope of her fiduciary duty. Julia confirmed one more piece. Harold's revocation deed recorded with the Washoe County Recorder on August 12, 2025. Document number 2025-RE871, voided Lloyd's quitclaim deed, which had been recorded July 28, 2025. Harold planned it precisely. He let Lloyd record the quitclaim, then filed the revocation 15 days later. The cabin remained trust property. When I saw the handwriting report, I did not feel triumph. I felt the specific heaviness of a fact you hoped was wrong. My youngest son forged his father's signature on a legal document and presented it to me as genuine. That is not a family disagreement. That is a crime. Julia assembled the full case file. 3 grounds for action: Constance breach, a fiduciary duty, and conversion of trust assets. Lloyd void deed unauthorized occupancy and trespass. Edgar forgery of a legal instrument and filing a false document with a public recorder. She drafted the letters on a Thursday, late August, week 4. Ruth sent me a text message. "Hope you're doing okay, Mom. Just want you to know we're all looking out for you. Lloyd talks about you all the time. Let us know if you need anything." I read it twice. I recognized the move immediately. In my career, we called this the concern text. The family member who helped loot the bank accounts sends a cheerful follow-up a few weeks later. It creates a paper trail of caring. It establishes plausible deniability. See, I checked on her. I was a loving daughter-in-law. I saw it 200 times in 30 years. Same tone, same timing, same hollow warmth. I did not respond. That same week, Constance contacted the Henderson House realtor for the 3rd time, pushing for a listing appointment. The realtor called me directly to confirm. "Mrs. Whitfield, your daughter has scheduled a listing appointment for next Tuesday. Can I confirm?" "I have not authorized a sale. My name is on the title. Please remove my address from your files." The realtor paused. "Ma'am, your daughter told me you had agreed to sell." "My daughter is not the homeowner. I am. Thank you for calling." I hung up. That conversation took 42 seconds. It was the first time I had directly contradicted one of my children since Harold's death. It felt like setting down a weight I did not realize I had been carrying. 3 days later, Lloyd sent a group text to Constance and Edgar. "Mom's being difficult about the house. Edgar, can you send her the amendment again?" He sent it to the sibling group thread. He accidentally included me. I read it at 6:15 in the morning with my coffee. They were still operating on their version of reality, the one where I was already done. First week of September 2026, the cease and desist letters arrived. Julia Keating sent them via certified mail return receipt requested to Constance's address in Anthem Lloyd's apartment in North Las Vegas and Edgar's law office near the courthouse. Each letter bore the letterhead of Silver State Trust Company and Julia's firm. The letters stated 6 things in numbered paragraphs. 1. The valid trust amendment dated October 8, 2025, supersedes all prior versions. 2. Constance Whitfield Bradshaw is removed as successor trustee, effective immediately. 3. All unauthorized transfers from the trust investment account must be returned within 30 days. 4. Lloyd Whitfield must vacate the Incline Village cabin within 14 days and return all keys. 5. The notice of trust filed by Edgar Whitfield with the Clark County Recorder based on a fraudulent document is void and must be withdrawn within 10 business days. 6. A formal trust administration meeting will be held September 8, 2026 at the offices of Silver State Trust Company, Las Vegas. Attendance of all named beneficiaries is required. Constance called me first, 40 minutes after the mail carrier left. Her voice was high and fast. "What have you done? We are your children." I said, "And Harold was your father." "Read the letter." Edgar went silent. He did not call. He did not email. An attorney who receives a cease and desist letter citing forgery evidence does not need it explained. He knows what comes next. Lloyd called last. His voice was different from the others. Quieter. "Mom, I miss Dad. His voice caught. For 3 seconds, he sounded like the boy I raised, the one who used to bring me dandelions from the backyard. Then Ruth's voice, muffled but audible from the background, "Ask her about the cabin." Lloyd's tone shifted, harder, faster. "We need to talk about the property, Mom. We have rights." I said nothing. I hung up. The meeting was in 6 days. Julia filed 2 documents that week. The first was a petition under Nevada Revised Statutes Section 163.115 filed with the 8th Judicial District Court in Clark County. The petition requested formal confirmation of Silver State Trust Company as successor trustee, removal of Constance from any remaining fiduciary capacity, and a full accounting of all trust assets and transactions from January 2025 through August 2026. The second was a formal complaint with the State Bar of Nevada regarding Edgar Whitfield Attorney License number 115227. The complaint alleged that Edgar drafted a fraudulent trust amendment bearing a simulated signature of the trust's settlor, filed the fraudulent document with the Clark County Recorder as a notice of trust, and presented the fraudulent document to a trust beneficiary as genuine. Attached Dr. Alan Finch's 9-page forensic analysis. The children hired an attorney, Garrett Cole, a litigator with a firm on Howard Hughes Parkway. Julia knew him professionally. She described him as competent and honest, which she said meant he would tell his clients the truth whether they wanted to hear it or not. Garrett Cole reviewed the cease and desist letters, the valid amendment Harold's documentation, Kendall Marsh's forensic accounting report, and Dr. Finch's signature analysis. He met with Constance, Lloyd, and Edgar for 2 hours. Julia told me later what Garrett told them, as relayed through professional channels. "I can represent you at the meeting, but I need to be clear. If this amendment is valid and the no contest clause is enforceable under NRS 163.01/25, a challenge would be extremely risky. You would forfeit your remainder interests entirely." Constance: "So we just accept it." Garrett: "I'm telling you the law. What you accept is up to you." The night before the meeting, I sat in Harold's study, the compass on the desk. I read his letter one final time. I folded it and placed it in my jacket pocket next to the compass. Tomorrow I would see all 3 of my children for the first time since the funeral. This time I would not be invisible. September 8, 2026, Tuesday, 9 in the morning. Silver State Trust Company occupied the 7th floor of a glass and steel building on South Las Vegas Boulevard downtown. The conference room faced east, floor-to-ceiling windows, morning sun. The Las Vegas Valley spread out below, hazy and flat and glittering. I arrived at 8:30. I wore a navy blazer, gray slacks, and low heels. Harold's compass was in my left jacket pocket. My wedding ring was the only jewelry I wore. Julia Keating arrived with 2 banker's boxes of documents and a legal pad. Karen Pruitt, the trust officer representing Silver State Trust Company, sat up at the head of the rectangular conference table. She was 48, composed, and spoke with the neutral authority of a person who manages other people's money for a living. At 8:55, the elevator opened. Constance entered first in a cream-colored dress and heels chin-up posture, rigid. Lloyd followed in a wrinkled sport coat, his eyes moving around the room without settling on anything. Edgar came last in a dark suit set briefcase in hand. Ruth stayed in the hallway. I could see her through the glass partition sitting in a chair against the wall, hands folded in her lap. Their attorney, Garrett Cole, took the chair beside Edgar. He nodded at Julia. She nodded back. Karen Pruitt opened the meeting at 9 sharp. This is a formal trust administration session for the Harold and Theda Whitfield Family Trust. I represent Silver State Trust Company as successor trustee under the amendment executed October 8, 2025. Constance said, "We dispute the validity of that amendment." Karen noted. Miss Keating will present the trust's position. Constance sat up straight. Spine of a woman about to perform certainty. I have seen that posture in 300 depositions. It never holds. Julia Keating stood. She placed a single document on the table, the original trust amendment, dated October 8, 2025. 2 witness signatures, 1 notary seal, Harold's genuine signature at the bottom. This is the operative trust instrument, Julia said, executed by Harold J. Whitfield on October 8, 2025, at the law office of Calvin Shea in Reno, Nevada. Witnessed by Mr. Shea and notarized by Diane Corbin. Mr. Shea is available to testify as to the circumstances of execution. Garrett Cole reached across the table and examined the document. He took his time. He studied the notary seal, the embossed stamp, the witness signature, the date. He compared it visually against a copy of the original 2004 trust that he had brought in his own file. He looked at his clients. He nodded once. A small, tight nod, the kind that says it is real. Julia continued. Article 7 of the amendment contains a no contest clause. She read it aloud slowly, the way a court reporter reads back testimony. Any beneficiary who directly or indirectly contests this trust instrument, seeks to impair or invalidate any provision herein, or challenges the appointment of the successor trustee shall forfeit their entire beneficial interest, including remainder interests, and shall be treated as having predeceased the settlor. Julia paused. Under NRS Section 163(95), this clause is enforceable. The statute provides limited exceptions for actions brought in good faith and with probable cause. Filing a challenge based on a competing document that contains a forged signature would not meet that standard. She looked at Edgar. Edgar did not look up. Constance's voice cut across the table. Dad would never have... Julia said, I have 3 more items to present. I suggest you hear them before you finish that sentence. The room went quiet. Outside the window, Las Vegas baked in the September sun. Julia placed the forensic accounting report on the table. Item 1. Between March and September of 2025, 4 unauthorized transfers were made from the Whitfield Family Trust Investment Account to the Personal Chase checking account of Constance Whitfield Bradshaw. She read the amounts. March 15th, $12,000. May 1st, $12,000. July 1st, $12,000. September 15th, $11,000. Total $47,000. Each transfer was coded trustee distribution, discretionary. However, the trust instrument contains no provision authorizing the successor trustee to make discretionary distributions to her own account. The forensic accountant's report confirms that these transfers constitute unauthorized self-dealing. Julia looked at Constance. This represents a breach of fiduciary duty under NRS 193.115 and conversion of trust property. Depending on the Clark County District Attorney's review, it may also constitute embezzlement under NRS 205,300. Constance's composure cracked along a single line the way a windshield fractures from one impact point. Those were administrative. I was managing... Julia, $47,000 in personal transfers over 6 months while your father was receiving chemotherapy. The brokerage records are time-stamped. There is no administrative justification. Garrett Cole placed his hand on Constance's forearm. The universal attorney signal, stop talking. Constance stopped. Her jaw worked silently. Her fingers gripped the edge of the table. Julia placed the Washoe County Recorder documents on the table. Item 2. On July 28, 2025, a quitclaim deed for the property at Incline Village, Nevada, was recorded purportedly transferring the property from the Whitfield Family Trust to Lloyd Whitfield individually. She set a second document beside it. On August 12, 2025, Harold Whitfield executed and recorded a revocation deed, document number 2025-42871. This revocation was prepared by Calvin Shea and recorded at the Washoe County Recorder's office. It voided the quitclaim in its entirety. Julia read from Harold's personal notes. Harold described the quitclaim signing as having occurred during a chemotherapy appointment while he was seated in an infusion chair with an IV in his left arm. He characterized the signature as given under duress and physical exhaustion. Lloyd shifted in his chair. His voice came out hoarse. "He wanted me to have it. He told me—" "Julia, Harold's recorded revocation indicates otherwise. The deed revocation is a public document. It was filed 15 days after the quitclaim." Lloyd looked at me across the table. His eyes were wet. "Mom, tell them Dad wanted me to have the cabin." I held his gaze. "Your father wanted you to earn things, Lloyd. He told me that every year of your life." Lloyd looked down at his hands. Through the glass partition, Ruth put her hand over her mouth and turned away. Julia placed Dr. Finch's report on the table. Item 3. In July 2026, Edgar Whitfield presented his mother with a document titled First Amendment to the Harold and Theda Whitfield Family Trust, dated September 2025. This document purported to bear Harold Whitfield's signature. She opened the report to the photographic comparison pages. Dr. Alan Finch, a certified forensic document examiner with 26 years of experience, identified 17 points of divergence between the questioned signature and Harold Whitfield's known signatures. Julia read the conclusion. The questioned signature is a simulation, a deliberate attempt to replicate the genuine signature. It is not genuine. She set the report down. Mr. Edgar Whitfield, a licensed attorney in the state of Nevada, drafted this document and presented it to his own mother as genuine. He also filed this document with the Clark County Recorder as a notice of trust, where it constitutes a false instrument placed in a public record. Julia read from Harold's letter. Edgar told me she had Dad's last years. We get the rest. He said it to my face during a treatment appointment in April 2025, while I was in the chair. The room was silent. The daisy cutter line landed for the third time, and each time it had grown heavier. First, Edgar said it to his siblings about me, then to his father's face while his father was dying. Now it was read aloud in a room full of witnesses. Edgar's voice cracked. I was trying to protect the family. Julia, a formal complaint has been filed with the State Bar of Nevada. Edgar sat back in his chair as though someone had pushed him. Julia addressed all 3 children. Under the valid trust amendment, each of you holds a remainder interest in the trust estate, contingent on Mrs. Whitfield's passing and contingent on compliance with the no contest clause. She spoke without urgency. The facts did not need emphasis. They had mass on their own. If any of you contests this amendment, challenges the appointment of Silver State Trust Company, or takes any action to impair these provisions, you forfeit your entire interest. NRS 163-95, your father gave you a choice. Accept the terms he set. Or fight and lose everything. Constance began to cry. Her shoulders shook. She pressed a tissue against her eyes. I have watched people cry in 400 rooms across 30 years. I learned to tell the difference between the cry of someone wronged and the cry of someone caught. The pitch is different. The timing is different. Constance was caught. Lloyd stared at the conference table. His hands were flat on the wood. He did not move. Edgar leaned toward Garrett Cole and whispered. Garrett shook his head slowly. Garrett addressed the room. My clients need time to consider their options. Julia. Of course. The no contest clause has no deadline for acceptance, but the forensic accounting, the forged instrument, and the breach of fiduciary duty findings are documented and preserved. They do not have expiration dates. The air conditioning hummed. The windows framed the desert. Nobody moved for 6 seconds. I counted. Julia looked at me and nodded. I stood. I was aware of the compass in my jacket pocket, the weight of it against my ribs. I touched it once through the fabric. I looked at each of my children, one at a time. Constance first, then Lloyd, then Edgar. Your father didn't do this to punish you. He did it because he loved me enough to protect me from what he saw coming." My voice was level. I had spent 30 years delivering findings in courtrooms and case conferences. My voice does not shake when I am certain. "Constance, you took $47,000 from your father's trust while he was dying. You said on the phone that I was already done. I was standing in the hallway. I heard you." "Lloyd, you put a pen in your father's hand during chemotherapy and asked him to sign away his cabin. He signed because he was exhausted. He drove to Reno the next month and took it back." "Edgar, you forged your father's name on a legal document. You presented it to me as real. You know what that means. You have always known." "I spent 30 years protecting people from exactly this. I never expected to need those skills at my own kitchen table." I sat down. Constance stood. Her voice climbed. "This isn't fair. We gave up years for this family. We supported Dad through everything, and now you—" Karen Pruitt spoke from the head of the table. "Please sit down, Mrs. Bradshaw." Constance sat. The room was silent. Through the glass, Ruth was crying soundlessly in the hallway chair. I did not raise my voice. I did not need to. 30 years of quiet authority is louder than any shout. Garrett Cole requested a recess. 5 minutes. The children and their attorney stepped into the hallway. Through the glass partition, I watched them. Constance paced. Lloyd leaned against the wall with his eyes closed. Edgar stood apart, his briefcase hanging from one hand like something he had forgotten to put down. Garrett spoke to them in a low voice. I could not hear the words, but I could read the posture. He was telling them what I already knew. They came back in. Garrett spoke for his clients. "My clients will not contest the amendment." Karen Pruitt recorded the decision. Julia Keating outlined the terms. Constance would return $47,000 to the trust within 60 days or face referral for criminal prosecution under NRS 205-300. Lloyd would vacate the Incline Village cabin within 14 days and surrender all keys. The voided quitclaim deed was confirmed void by the recorded revocation. Edgar would withdraw his fraudulent notice of trust from the Clark County recorder within 10 business days. The state bar investigation would proceed independently of this meeting. All 3 children retained their remainder interests in the trust estate. Conditional on my death, conditional on no contest, conditional on full compliance. Silver State Trust Company assumed full trustee authority over all trust assets. Karen Pruitt said, "This meeting is adjourned." I stood. I walked to the elevator without looking back. Julia followed with her file boxes. The elevator doors closed. I opened my hand. Harold's compass. The needle pointed north, the same direction it had pointed for 40 years in every mine and tunnel and desert road Harold ever worked. I did not win. Harold did. He just was not there to see it. 6 weeks after the meeting, I sat in my backyard in Henderson and watched the quail move through the sagebrush along the back fence. The Meyer lemon tree Harold planted in 2008 had fruited. 8 lemons, small and bright, more than we ever got in a single season. Constance wired $47,000 to the trust account on day 58 of the 60-day deadline, 2 days from the criminal referral. She has not called me since the meeting. Douglas filed for personal bankruptcy the following week. The Anthem House went on the market. Lloyd vacated the cabin on day 12. His North Las Vegas townhome project went into receivership the following month. He and Ruth moved to a rental apartment in Summerlin. The contractor Lloyd hired for the cabin renovation filed a mechanic's lien for unpaid work, $11,600. Silver State Trust Company settled it from trust funds as a property maintenance expense. Edgar was placed on interim suspension by the State Bar of Nevada, pending a formal disciplinary hearing. His solo practice closed. The office near the courthouse is empty now. Ruth sent me a handwritten note, 4 sentences on plain white paper. "I am sorry for what I did in your home. I am sorry for the photographs and the boxes. I should have told Lloyd to stop. I did not. No excuses, no request. It was the only apology I received that did not come wrapped in a demand. I kept the note in Harold's desk drawer. I did not respond, but I kept it. On a September evening, I drove to Palm Mortuary and sat on the stone bench beside Harold's grave. The desert air carried the smell of sage and cooling rock, the same smell that clung to Harold's jacket every time he came home from a mine site or a long drive north. The cemetery was quiet. A groundskeeper watered the grass 3 rows over. The sprinklers ticked in the stillness. I held the brass compass in my palm. 40 years of scratches and field dust and the oil from Harold's thumb on the lid. I placed it on the headstone and watched the needles settle. You plan this from a hospital bed. You could barely hold a coffee cup by October, but you drove to Reno 3 times to make sure I would be safe. The sun dropped behind the spring mountains. The air cooled. A mourning dove called from the fence line. You didn't leave me money, Harold. You left me the truth. You left me the only thing that couldn't be forged or redirected or taken while I wasn't looking. I picked the compass back up and slipped it into my pocket. I'll keep this a while longer. I'm still finding my way, but the needle's steady. I spent 30 years investigating families that fell apart over money. I always believed I understood it. I did not. Understanding it from the outside and living it from the inside are 2 different professions entirely. The files close. The feelings do not. My children are not gone from my life. They are at a distance I chose. The door is not locked. But the terms have changed. If they come closer, it will be because they learned that I am not a line item on a spreadsheet and never was. I do not need their permission to live in my own house, drive to my own cabin, or spend my own Tuesday however I please. Harold knew something I was not ready to accept. Love does not always look like forgiveness. Sometimes it looks like a notarized document in a brown accordion folder signed by a man who could barely hold the pen but refused to let go until the ink was dry. Sometimes it looks like a compass that always points true. That is my story. 11 months of planning by a man who could not save himself but found a way to save me. 4 days of silence, 1 sealed amendment, and a family that learned the hard difference between an inheritance and an entitlement. If this story reminded you to review your trust documents or to ask who your successor trustee really is, take that as a sign. Do it this week. Ask your estate attorney about no contest clauses. Ask who would really protect your spouse if you were gone. If you know someone who has been treated as invisible by their own family, share this video with them. Forward it. Text it. Let them hear it. Sometimes the quietest person in the room is the one who spent 30 years learning exactly when to speak. Thank you for being here. Drop a comment, hit subscribe, and I'll see you in the next one.